Item number 9 is a resolution urging Senator Amedee to enact a Senate bill and amending Part 11 of Title 19 of the Louisiana Revised Statutes of 1950, expropriation by a declaration of taking by the Parish of Ascension.
Senator Amedee is doing Senate Bill 703.
Madam Chairwoman, this is a local bill dealing with Ascension Parish only. What this bill does is simply give the parish the same authority as the state has as it relates to expropriation. Parish President Tommy Martinez here.
I'm in support of Senator Amedee's bill. We passed, as he said earlier, a resolution 8-3.
Our whole delegation supports it. The chairman of the council. Also here, Mr. Chris Lohr.
I would like to be on the record as supporting this.
Benny Johnson on the council. Then I have Senator Brown here also.
Basically, I want to just rise in support of this bill. The City of Orleans Parish has the ability to do just what we're asking to do. As well, the East Baton Rouge Parish.
Baton Rouge did have it for a specific project. That law is off the books.
And we're only asking that this applies to Ascension Parish as well.
There was a resolution passed by the council last week.
The judge decides what's
right. At court, everybody has the same due process.
Councilman Satterley.
This motion shall be tried contradictorily with preference to the judge alone, and that means without a hearing. Now, let's talk about ex parte. If this bill passes, the process would be ex parte. It means, quote, no jury, no evidence, and no trial.
Now we're going to have an ex parte order. That's something that can be done without the presence of the parties.
And it's a term meaning from, by, or for one. Emphasis on the word one, a single party. An ex parte decision, quoting again from the dictionary, is one decided by a judge. We heard about that tonight.
the judge decides what's
right. Notice, it didn't say a trial. It didn't say a jury. It didn't say anything about oral arguments. That's what a hearing is.
Paragraph B sets forth that the landowner on line 11, if he does not object, but there's no mechanism when he gets a letter from the parish on how he is supposed to object to his property.
But a judge, without requiring all the parties to the controversy, in other words, a judge can just do this in his chambers, at home, whatever. He can read what we say is necessary and useful to the parish. Both the federal and state courts in our country are sharply divided by a little thing called the Fifth and the 14th Amendments.
This is not unconstitutional. It's never been ruled unconstitutional. But when people start yelling unconstitutional, it's usually because they're just against the bill.
So that flies in the face of the Constitution,
which provides that a person shall not be deprived of any interest in liberty or property without due process of law.
The beginning of the Constitution says we're going to protect the rights of property owners, but yet we're going to vest title in line 26 to the parish right away without any type of hearing or due process.
Everybody has the same due process.
What does that mean? An opportunity be given to be heard.
And if you look at line 12, that he will waive all of his defenses.
And the person or persons affected by such orders must be given an opportunity to contest the appropriateness of the order before such order can be made.
So the judge decides what's
right. Permanent. Where's the hearing? You would object to the word hearing behind contradictory, is that correct?
It's just with the statute. We're tracking the state statute. I'd object to any changes in that because you're going to wind up with a problem.
He wants to have a hearing to determine the public purpose.
I'll just state it right now. I think we should turn this down.
I just got the bill actually this morning on email. I know there was a rough draft sent to Senator Amedee roughly a month ago. I think it would have been smart to give all the councilmen a rough draft so we had something to start working with. But that's why this rush. That's my biggest problem is 2 days before the council meeting, and we got to move on an issue that's going to affect the citizens of this parish big time.
It is a due process that, in fact, a decision can and will be made in a courtroom, very much like the one, if not the one, we are sitting in.
So the judge decides what's
right.
And unfortunate as it may be, this is what has to happen to make that happen.
Local government wants to or needs the draconian procedure of quick take.
And I've spoken with the city's attorney. The city of Gonzales has quick take.
I think the city of Gonzales has it.
I don't see anywhere where the city of Gonzales has quick take authority in this current statutes right now.
They utilize it. They utilize it as frequently as they have to, but they have it.
Let us never negotiate out of fear.
We have got to have this. We have to have the public safety in mind, and we have to have the political will to get it done.
Councilman Malonzo.
Yeah, Ms. Castro, I agree that we need to have the public safety in mind, but I think we also need to have individuals' rights in mind. And I very much don't take lightly any time anything comes up that will in any way infringe on any property owner or any citizen's rights. And so to say that you can't put this off any at all for a resolution and a bill that first time I saw a resolution was Monday night. First time I saw a bill was this morning. I made calls to people, to lawyers that I know, some of my good friends that could give me a call. I haven't heard back from them yet. They haven't had time to answer. I haven't had time to do enough research to make a decision on this. And to say that it's putting the public safety not in mind by not taking the time to make sure that it's researched enough that we have the information we need to make a proper decision, I don't think is right. And on top of that, Doc mentioned the St. Mary bill, which actually would have bore the same numbers as this bill. That was written last year. It was stalled. I'd like to know what happened with that bill. It passed through the Senate, got to the House, and it was killed in committee. What's the problems they found with that bill? I haven't been able to get an answer on that yet. I mean, we need more time to research this before we just push it out.
But we have to pass the bill so that you can find out what is in it.
Senator Cortez, you have a question?
Thank you, Madam Chair. This may be for the parish president. Senator Amity mentioned that there was an 8-3 resolution. Tell me real briefly what the opposition...
They actually really weren't opposed to it, but they wanted the amendment to make sure that the amendment was in there and that didn't say major infrastructure.
At a minimum, we need to push this back 2 more weeks and make sure we have enough time to research it and get all the facts.
We do have a lot of problem with the judges making a decision up front that the taking part's over without a hearing.
That's my biggest problem is 2 days before the council meeting, and we got to move on an issue that's going to affect the citizens of this parish big time.
This bill, I've worked with people to make amendments before I even filed it.
How can any of us do any kind of reasonable examination of this in less than a 24-hour period of time?
That never actually arose in opposition of it. They just had some questions.
And it was all about major infrastructure, the buildings.
Yes.
I think by saying that you don't have, under quick take, you don't have due process, I don't think that's the correct statement. Because I think you have more due process. If you don't have this too, as part of your package, you can certainly check with other municipalities, other parishes, the state, and you will see what happens. You won't get these projects done.
And we need the tools to be able to build roads, and certainly we don't have parish-wide sewer, and we're going to need that tool also there.
So remember, Ascension Parish right now has the right to expropriate property, just like any other municipality or parish does.
We have Section 413 of the parish charter. It's entitled, for Ascension Parish, Power of Eminent Domain. We've heard already tonight that we already have a law. The governing authority shall have the power of eminent domain and the right to expropriate property. That's covered under state law.
The House passed a constitutional amendment that was adopted by the voters, setting up the expropriation process for the state of Louisiana. That's Article 1, Section 4.
Without as well as within the parish for public purposes as provided by state law, governing authority shall make fair and just compensation. The parish president said it's not introducing anything new.
Now, today, what we're talking about is going on in Ascension Parish. I mean, we're not introducing anything new.
The way the parish is now, they have expropriation power.
The parish president said it's not introducing anything new. If that's correct, Why do we need a new replacement? Certainly something must be different about it.
Parish can go now and take the property. It's just not
I
quite as
understand
quick. Parish can go now and take the property. It's just not
I
quite as
understand
quick.
that.
Let's look at on page 2, line 5. The declaration is it's necessary or useful. It's not what the public purpose is. Necessary or useful. If you look at Webster's, that's capable of being put to use. That's simply all that is. So if the property is capable of being put to use, it's useful and therefore can be taken. Look at line 14. It's the money estimated. And who's doing the estimating? This isn't an appraisal. This is an estimation by local government of what someone's property is worth. Local government wants to or needs this draconian procedure of quick take.
Safety-wise, where you have Stringer Bridge Road by Randy's house, where the 2 children drowned. I do not think in any way, shape, or form we are taking due process away from our system. It's giving you just the ability to get the job done.
And when it comes to an issue like drainage, I think this is actually adding a lot more transparency to the process that we've been using for years around here. And this right here gives them the ability to add more time or not necessarily more time, but more rights to go fair in a reasonable manner. This is one of those things that I too will support move forward tonight. I think it's the right way to go, and also make sure that we are doing right by the people, and I think this helps out.
Councilman Joseph?
Yeah. My biggest concern is the infrastructure. We have to be honest with the public. We leave that big in it, that's going to put that doubt in. So, you know, one of the most important things is to remove that infrastructure word out of it.
Let me call on Councilman Kluwak first.
Basically, some of the concerns I had at looking at this over the past months, I don't have a problem backing this tonight.
2 days before the council meeting, and we got to move on an issue that's going to affect the citizens of this parish big time.
I mean, we need more time to research this before we just push it out.
How can any of us do any kind of reasonable examination of this in less than a 24-hour period of time?
So we're going to have an ex parte order on line 20, and we're going to declare that it's taken for a public purpose. So there's no evidence there. We're having a declaration that it's for a public purpose without the landowner being able to formally object and put before the judge, who the Constitution says is the one who's the trier of fact on this, that it's for a public purpose. And then the judge is going to direct that the amount of the estimate, which is on line 23, be deposited in the registry of the court. This is not the appraised value of the property. This is the estimate by local government.
Parish can go now and take the property. It's just not quite as quick.
So we got an ex parte order where the judge is saying, yes, it's a public purpose, and here's the estimate of the money we're putting in the registry of the court, without the landowner, the owner of the property, ever putting forth any evidence that, A, it's not for a public purpose, and this estimate is a very low number. I mean, we don't have any of that. So the parish owns the property now without the property owner ever having a chance to contest the public purpose or the estimate, if you will, of the property. And then we're going to notice the defendant after the fact. After this has all been done to him with this ex parte by the judge, Section 365 talks about notice of the defendant. It's on page 4, if you will. We're going to notify him of what? That his property, described in the petition, has been expropriated for public purposes. Remember, there's never been a determination by the judge that it's for a public purpose, that the Constitution requires there to be. And how much time are we going to give him for some of these unsophisticated property owners? Senator Clome, on line 15, we're going to give them 10 days. So they're going to have 10 days to come in, get a lawyer, and object. Or guess what happens to them at that point? They're going to lose their defenses in line 22. Waiver of all defenses. This is draconian at best.
And since it was requested by our parish president and our chairman, they must have thought we needed something new.
That motion is passed.
What's the pleasure of the committee? Hearing none, then that bill is deferred.